So this is the third and final lecture that Eleanor's giving on this fascinating subject of essentially the innards of the Court of Justice, or as much as she's free to say, given the duties of confidentiality to which she's bound. She is going to talk for sort of half an hour-ish.
A little bit longer than that, and I will try and leave room for questions on it.
Yeah, and we will be done today at just after 10:02, because I know various people have got things to get to for 2 o'clock. There are some very fine cakes going around. Please make good use of them. There's sometimes there's no such thing as a free lunch, but actually today there is a free lunch. There is no caveat. So please, please, please help yourself. Leo, the floor is yours.
Thank you. Right, good afternoon, everyone. And I am deeply impressed, and I do mean deeply impressed, by how many people have still managed to get here on what is the last teaching day of term. That is a great tribute to your desire to know more about the inside story of the Court of Justice. Obviously, this third seminar links on from its two predecessors about language on the court and about decoding the Court of Justice judgments. And equally obviously, a lot of what I've already said in those two seminars will feed into this discussion. There are some parameters I want to suggest you should bear in mind when thinking about the interaction between the court and its advocates general. They're really fairly obvious, but that may not mean that it doesn't bear repeating. First of all, the difference in roles between the Advocate General and the bench. The Advocate General is out there exploring all the facets of the case, trying to look at the options available to the court, trying to gaze into a crystal ball. Unfortunately, we're not issued with one upon appointment, and sometimes you feel it would be helpful, and then trying to suggest to the court the way in which we think that the court should resolve the matter before it. Bearing in mind, we sometimes have to go the very long way round. We have to deal with everything, and we may do that fully expecting that the court will take the shortest route home, because that's what courts normally do. There's also the different style of reasoning. The Advocate General, very individual voice, which is a great honour and a great responsibility. The court, consensual, because we don't have dissenting judgments. I'm happy to explore that further later during question and answer if anyone wants to. Something which maybe is less obvious, we don't have the relationship between the Advocate General and the court, which is the relationship of a first instance court to an appellate jurisdiction. And there is indeed no way of infuriating an Advocate General so rapidly as by suggesting that they're the judge at first instance, and then, of course, the courts, the wiser and more experienced people upstairs will see if they endorse what you say. That really is a good way of winding up any Advocate General, including this one, that I've ever met. It's not that relationship, but precisely because it isn't that relationship, possibly we should not expect the court to engage with the Advocate General in exactly the same way that an appellate jurisdiction engages with the judgment of the first instance court that it's reviewing. Because in that context, you know what the grounds are of the appeal, you have the parameters of the appeal, and you expect the court to engage directly with what the court below has said and either endorse it or depart from it, and then see what the consequences are. But that's not really what's happening here. So, all right, you maybe shouldn't expect that degree of intense interaction. Having said that, we all know that there is this kind of famous phrase about the dialogue between the Court of Justice and its Advocates General. And I do suggest, and I'm very prepared to suggest that at the beginning of this seminar, that if the court wants us to take seriously the idea of the dialogue between the court and its Advocates General, well, you know what? It would do us all a favour by being slightly less Delphic about what that dialogue actually is. Now, I'm going to nip through some illustrations. They're not all my own cases. Some of them are. But I I'm obviously going to do it very quickly because of the time constraint. And who knows, maybe it will be possible to explore some of that later in some other forum or some other way. First illustration, same destination, but who knows what happened. This is, of course, case C3409, Ruiz Zambrano. Ah, yes, a lovely big juicy case on citizenship of the Union. The Advocate General, not initially myself, I had originally allocated it to my Spanish colleague, Advocate General Ruijabo Colomer, but I got it back after his very sudden and untimely death. And I wrote the opinion with one of his lovely referendaires, Daniel Sarmiento, rather than with one of my own team. We rewrote the thing 4 times. We ended up with an opinion whose conclusion is expressed in paragraph 178. So you can tell it was rather an extended analysis. And we did suggest that the court should say there was a right of residence in the territory of the member states based on citizenship that's independent of the right to move, that it might be possible to refuse to grant a derived right of residence if you respected proportionality. And we did say you shouldn't have reverse discrimination. You had to bear in mind, however, the fundamental right to family life. You couldn't invoke that independently, and it was all very elaborate and very careful. So it was 178 paragraphs and 152 footnotes. And then the court gave us its judgment. And when the court gave us its judgment, if you exclude the bit up the front, which is, of course, repeating everything we knew about the facts, and then dealing with the questions, the section that answers the questions referred for a preliminary ruling is 8 paragraphs long. And I have to say, I may be the Advocate General in the case, I'm absolutely no wiser than you are as to how the court got to its answer. I mean, I observe we, roughly speaking, ended up in the same place, but please don't interrogate me on what the court's reasoning was, because I'm as much in the dark as you are. Second example, a situation where neither the court nor its Advocate General really had an answer to a completely intractable problem. The illustration here is from the 2015-2016 refugee crisis, the moment at which the West Balkans route, as it was known, the land bridge from Turkey, is being tramped along by about 750,000 applicants for international protection, many of whom the debris field from what was going on in Syria, but also people from other places where there were troubles. And we got a series of cases. And I had the dubious honor of being the Advocate General with whom the court disagreed. The cases I'm going to refer you to, there's a couple of cases which are C490 of 16 AS and C646 of 16 Jafari, which I've dealt with together, the 2 separate judgments of the court. There's also a case, we're all part of the same story, case C670 of 16 Mengestape. Now, essentially what you have is this mass of humanity tramping up the West Balkans route. And they go into Greece, but we know that Greece is chock-a-full, so they come back out again, they go on up the land, and they come back in across the Croatian frontier. And the Croatian frontier, ladies and gentlemen, is open. The border guards are there. They are busy waving people through the frontier. Madam, come along. Oh, your little boy needs a toilet. Yes, there's some around there. Water's over there. Blankets, yes, blankets. The buses are down there. Come on, please. Move along. So the last thing the border guards are doing is keeping people out, for the good and sufficient reason that winter is coming on. If they seal that border, there will be a humanitarian crisis along the border. There will be tents as far as anyone provides them with tents. Médecins Sans Frontières are going to be there. The UN disaster relief people are going to be there. It is going to be a catastrophe. And so the border is open. Now, whose responsibility is it going to be to look at those applications for asylum? 750,000 people, population of Croatia, about 4 million in round figures. The arithmetic doesn't really add up. Besides, we know, Mrs. Merkel has said, wir schaffen das. We know that they're trying to head on to Germany. They're going on towards Austria. There are other places, right? We also know, and this I'm going to be cheeky and refer you to the opening paragraphs of my opinion, which begin by saying, if you look at a map of Europe, it's clear that people will not be coming in to exactly the same extent over each of the frontiers all the way around the European Union. Look at the geography. However, the Dublin regulation, which allocates responsibility, doesn't work like that. It kind of assumes that everyone gets dropped by helicopter or by flight, very roughly, equally in all the places. In this situation, the Dublin regulation was never designed to deal with what it's trying to deal with here. Well, the court and the Advocate General certainly didn't find the same solution. To me, it seemed very strange to interpret Article 13 of the regulation, which is about irregular frontier crossings, as being something that covered this situation, because you had the frontier guards telling people to come across the frontier. They weren't crawling under the barbed wire fence. And so I can see the reason why Article 13 is normally invoked. It's invoked a lot of the time for sending people back to a different member state. And the underpinning rationale is, you were careless, you let these people into the EU because you don't keep a proper frontier. Therefore, you should process their application. But that didn't really seem to me to match the reality. The court went straight with Article 13. That was half the story. The other half of the story was Mengesteb, because Mengesteb was about the amount of time, when time runs from, if you're calculating when the application goes in for asylum and when you have to decide, because that also has an effect under the Dublin regulation. If you don't decide in time, then you're stuck with the application. You want to send them somewhere else, you have to process it. And here again, the court and I reached opposite conclusions. I was looking at the situation of the German authorities trying to handle all these applications, and I was being a bit more flexible in terms of when time started from, because looking at what was actually put in, I didn't think that you could start the clock running at the very first moment. The court was much stricter about how time ran. Where did all that leave us? Well, I never did an accurate calculation. I don't think such a calculation would have been possible. But very, very roughly, if you'd taken my two solutions, A.S. Jafari and Mengesteb, and then you took the court's two solutions, maybe at the end of the day, we roughly speaking ended up with very roughly the same number of asylum seekers in the two places, but by different routes. But who knows? The underlying story being, this simply wasn't the Dublin regulations forte. This is not what it was meant to deal with. Third example, which I labeled a new problem, a new solution. This is taking us back. You'll be happy to hear we're moving away from my cases. This is taking us back to the creation of state liability for damages in joint cases C6 and 9. Of Catherine, you may have the year in. Thank you, 1990. I see I failed to fill that the year in the handout. Thank you, Professor Barnard. There, we needed the Advocate General to go ahead of the court and do some creative thinking. Think about what we're doing to stretch back into the past, into Humblé and into Rousseau, and then to more recent case law, Zuckerfabrik, and the Advocate General built on the need for both effective protection and uniformity of rules, relies heavily on Zuckerfabrik. The court picks up the ball and runs with it and does pretty much the same line of analysis in its Frankovich judgment. Fourth example, getting stuck and looking to the Advocate General to help you move forward.
this is the extended mess that was joint cases C397 to C40301, Pfeiffer and others. This is a working time directive, but a very complicated version of the working time directive. And it's partly an illustration for you that the court doesn't always get case allocation right, because that case was initially allocated to a chamber of 5 judges, and it was going to be determined, obviously, with an opinion, but without a hearing, because, you know, we can get on with this, we can process it. First, Advocate General's opinion from Damaso Rija-Bocolomer was on the 6th of May, 2003. And the Chamber of 5 read the opinion and said, oh dear, to itself. It referred the case back to the full court. There was an order in January 2004 reassigning the case to the Grand Chamber, reopening the oral procedure, which you had to do because the Advocate General's opinion is the last step in the oral procedure. After that, it's the deliberation. So if you were going to reallocate the case to a different formation of court, you needed to reopen the oral procedure. And for the same logic that says this needs to go up to the Grand Chamber, also naturally said it's going to need a hearing and it's going to need another Advocate General's opinion, and then we can start deliberating it in the enlarged formation of court. So there was indeed a hearing on the 3rd of March 2004, which was attended by the parties and also by Germany, France, Italy, the UK and the Commission. And we get a second Advocate General's opinion on the 27th of April 2004, the Advocate General doing their very best, you know, to move it along. We then get 5.5 months before the court gives judgment on the 5th of October 2004. So, you know, the system worked in the sense that the Advocate General is really there to assist the court. And the Advocate General did assist the court. If you look at the start of the second opinion, you'll see that he says very clearly, everything I said in my first opinion, take it as read. I'm dealing with the situation problem about the third question, and I'm dealing with it against the background. I know the court's got trouble with that question because it's reallocated this case to the full court. Fifth example, a slightly provocative title. The Advocate General has cojones, the court maybe not so much. Advocate General Francis Jacobs, of course, in UPA, in case C5000P, Unión de Pequeños Agricultores, against counsel. This was a magisterial opinion from Francis Jacobs. I mean, there's few opinions about which one can say, you know, 20 odd years later, this was a landmark opinion. This was really, really a blockbuster opinion. But Francis's opinion in UPA absolutely fits that bill. He produced immensely convincing arguments as to why the very restrictive rules on locus standi for direct actions were too restrictive, were a denial of justice. He also came up with the wonderful tag that if you look at the Court of Justice, the side door by which he meant the reference procedure is not always available, and the front door is sometimes firmly locked, as in the direct action. So convincing was Advocate General Jacobs' opinion that in the gap between the opinion and the court's judgment, the General Court followed Advocate General Jacobs in the first instance judgment that it gave in case T17701 Yegoquere, because it was totally convinced by what had been written. Then the court decided the appeal in UPA and disagreed with Francis Jacobs. It's a slightly curious judgment because in paragraph 43 of that judgment, the court cross-refers to the Advocate General's opinion
but in a slightly misleading way, because it quotes something that Francis Jacobs did say, but that's not really the main thrust of what he was talking about. And then it goes on in paragraph 45 to engage with the Advocate General, albeit indirectly, it doesn't name him. And in the court says, it's admittedly possible to envisage a different system. And then they shy away from it. But, you know, if you talk to judges who were involved in that case, they would say, well, maybe judges are right to be more cautious than advocates general about simply taking jurisdiction. At least the court flagged up the problem for the member states, for the Herren der Verträge, the masters of the treaty, and said to them, you guys had better consider this. We can't do it. Now, I'm going to put in a slightly mischievous footnote and say, excuse me, you can't do it. Well, but maybe let's just look at who defined the key terms, the key treaty terms, in such a restrictive way in the first place. Not the Herren der Verträge, you the court, right? So, I mean, I understand the reasoning, but obviously, since I'm an ex-advocate general, I'm in favor of being bold and taking jurisdiction. And other advocates general very recently have been following that, thinking it's good to take jurisdiction. I'm thinking of the recent opinion by Advocate General Capita. It's good to take jurisdiction and then, okay, perhaps decide that this is something where you're not going to interfere with a margin of discretion. But okay, the General Court was wrong, therefore, to follow Francis Jacobs when they decided Yeguquere. So then the court has to reverse the General Court's decision in Yeguquere, which it duly did in case C26302P, Commission against Yeguquere. And then we get the Convention on the Constitution, and then we get the Treaty of Lisbon. And the Treaty of Lisbon changes the locus standi rules. They don't go exactly where Francis Jacobs would have suggested that they went, but they do make changes. I'll tell you something really curious. When I was preparing to give this seminar, naturally I went onto the Curia website because I wanted my copy of Francis Jacobs' opinion in UPA. Neither Curia Europa EU nor an equivalent search in Eurolex immediately yielded Francis's opinion. They both just gave me a link to the judgment. I thought, this is very, very strange. What is going on? If, however, you Google Advocate General Jacobs' opinion, UPA, you will get the text of the opinion. I am not a conspiracy theorist, so I'm not going to suggest to you that this is deliberate suppression by the community institutions. I think it's the cock-up theory of history, which, as usual, is the one we should believe. Right. The next example is where the court does expressly cite the Advocate General in order to tell us not very much. You think, well, why on earth did they bother to cite the Advocate General there? My example is another very well-known case, case C6416, Associação Sindical dos Juízes Portugueses, the Portuguese judges case. And in that case, the court very solemnly says, in the present case, as the Advocate General observed in point 32 of his opinion, the dispute before the referring court in the main proceedings concerns the annulment of the administrative measures under which the remuneration of members of the Tribunal de Contas, the Court of Auditors, was reduced, and the reinstatement of sums withheld pursuant to Law Number 76, 2014. I quote, that information comes straight out of the order for reference. It does not represent some special flash of inspiration or legal insight on the part of the Advocate General. There it is in the order for reference. And indeed, in the very next paragraph, the court goes on to refer to the file submitted to the court. This is the National Court's file, which is sent with the order for reference and which very often contains useful additional material. It refers to that file from which it was quotes apparent, close quotes, that the amounts withheld from the remuneration of the persons concerned had not been repaid to them, And it then concluded that the main proceedings have not become devoid of purpose and that the order for reference was therefore admissible. Now, that wasn't actually what the Advocate General, what was quoted was not really what the Advocate General was talking about at point 32 of the opinion. If you try and track through what was going on in the opinion, you will find that there were two objections to admissibility, right? What was it necessary? Did you have to deal with the reference? To which the answer was yes. Those two references, you can find the material in the Advocate General's opinion. You can find parallel opinion material in the court judgment. Had the court, both the Advocate General and the court, concluded that those two objections should be rejected and that the reference was admissible. Had the court wanted to show clearly that it agreed with the Advocate General's reasoning and conclusion on both the challenges to admissibility, you know what? It could have said so in a single sentence and saved everyone a lot of space. And this very elaborate analysis, I wonder whether the Advocate General said something particular. Let me go and look at the Advocate General. No, he wasn't talking about that. Now, I've just said it could endorse the Advocate General. Well, there is one example that I know, and one only, of exactly that happening in a judgment of the court. And I'm greatly indebted to Judge David Edward, a very, very dear and very old friend, for helping out my memory on this. There is a case in which Judge David Edward was the reporting judge, case C59 of 92, Hauptzollamt Hamburg St. Annen against Eber Sönichen GmbH. This is one of those cases which, when you do it and then you sigh with relief, and you say, thank God I've done that. I don't need to visit that ever again. It was a case about determining the customs value of defective goods. It went to the first chamber. So you had Rodriguez Iglesias, later president of the court, as president of chamber, Judge René Joliet, who was an extremely solid, experienced member of the court, and Judge David Edward. So chamber of three judges, Advocate General, Monsieur Marc Darmon. And the judgment in that case sets out, it's one of the shortest judgments, I think, on the record in the court. It says, we got an order from the Bundesfinanzhof on this problem. Here are the questions that were referred to us. Reference is made to the report of the juge rapporteur for the facts in the main proceedings, the procedure before, and the written observations submitted to the court. This was at the time when there was a published version of the report for the hearing, and that was an absolutely stock phrase. And the judgment then says, paragraph 4, for the reasons indicated in the Advocate General's opinion of 31st March 1993, the reply to the question put by the National Court must be. And they set out what the answer is. And then there's the standard formula about costs. And then you get in bold the dispositif, repetition, second sentence of Article 4 of Commission Regulation, blah, is to be interpreted as meaning that in the event of a deterioration of goods which reduces their customs value, no differentiation is to be made according to whether it occurred before or after the risk passed to the buyer. It is the shortest judgment I know of the court. I did ask Judge Edward if there was a bit more background, and I got a lovely email from him. It was said, I remember that there was criticism from others on the ground that the court has to come up with its own decision and not rely on that of others. And I don't think it was repeated, by the way, nor do I. Though a bench including Rodriguez and Joliet was, by any standards, sound enough. I would respectfully agree. Darmon was the AG, and he was pleased. There was a French magistrat, he wasn't conseiller d'etat, he was the other side of the judiciary. As a French magistrat, one might have expected him to be picky and to procedure. So there we are. So we had a clear example, but it wasn't followed in other cases. But here's the interesting twist, my final illustration for you. Please note that this or something like this is precisely what the court is now doing with trademark appeals that are dispatched quickly by reasoned order as being manifestly inadmissible and or unfounded. In those cases dealt with by reasoned order, the Advocate General does all the work and supplies all the reasoning. Now, there is a kind of upstream procedure in the sense that these cases have to be picked out by the Research and Documentation Division, a sort of filtering thing. This is potentially a case which could be treated in this way. Then the Advocate General and the reporting judge have to agree that it can probably be treated in this way. It then goes through the general meeting of the court on a special extra separate list, separate from the two normal lists for judicial case handling. And if nobody says, I don't think we can do it like that, then it is treated as being one of these special cases. The cases are very good for the court statistics because the Advocate General is under the cosh to produce his or her point of view on this case within a really, really tight time frame so that it can then be rubber stamped by the chamber and be sent off as the reasoned order. I dug out one of these, which I only half remember, but I do remember doing in the middle of everything else when I was at the court. It's case, which is case C29319P, called Et Gilli. And if I tell you that the order of the court was on the 2nd of October 2019, you will appreciate that by that stage, I was juggling so many balls trying to get opinions done and trying to do with this, and with Brexit and Brexit dates all shifting. You will forgive me if my recollection of the case is less impeccable than it might be. But the case, it was a trademark appeal, and it was about the registration of the figurative sign Gilli as an EU trademark. If this is sending you to sleep, you have my sympathy, right? It had that effect on anyone who had to do these appeals. If you look at the order in Gilli, the order starts off by saying there's an appeal. The appeal seeks to have set aside the judgment of the General Court, the judgment under appeal, by which the General Court dismissed its action for annulment of the decision of the Fifth Board of Appeal relating to opposition proceedings between Mr. Victor Lupo and Et Gilli Soil Jilhangir Ibrahim, the contested decision. Remember that these cases have gone through a whole raft of review procedures before they get up to the Court on Appeal. And so we then have, by support of the appeal, the appellant relies on a single ground of appeal. He alleges infringement of Article 8(1)(b) of the trademark regulation. And then we get the observations pursuant to Article, and then we get the appeal. The court itself says this: pursuant to Article 181 of the Rules of Procedure, where the appeal is, in whole or in part, manifestly inadmissible or manifestly unfounded, the court may at any time, acting on a proposal from the juge rapporteur and after hearing the Advocate General, decide by reasoned order to dismiss that appeal in whole or in part. Now, so far so good, that's the standard procedure for a reasoned order. Then we have the following. On the 23rd of July 2019, the Advocate General, humble servant, took the following position. There is a colon, and then there is an opening set of quotation marks. The text of the order then recommences with the numbering 1, as in the first paragraph of what I wrote. And it literally sets out verbatim the position that the Advocate General took, going all the way through to paragraph 26 of what I wrote. Therefore, in light of the foregoing conclusions, I propose that the Court of Justice dismiss the appeal pursuant to Article 181 of the Rules of Procedure on the ground that it is, in part, manifestly inadmissible and, in part, manifestly unfounded. Full stop, end quotation marks. New paragraph from the court. For the same reasons as those given by the Advocate General, the appeal must be dismissed as being, in part, manifestly inadmissible and, in part, manifestly unfounded. And then there's the formula on costs. And then on those grounds, the court, 8th Chamber, hereby rules the appeal is dismissed as being, in part, manifestly inadmissible and, in part, manifestly unfounded. Now, I think that takes me through to some concluding remarks, which possibly begin with the word, what do you want your Advocate General to do? Do you want to use the Advocate General as additional extrajudicial manpower? Because that's actually what you're doing with the example that I just gave you. And I say that because the way that the procedure is actually handled, the whole idea is that the court, the chamber, is going to rubber stamp what the Advocate General wrote. If the chamber doesn't rubber stamp it, but actually goes into the detail of the case, it is a shocking waste of Advocate General time to get the Advocate General doing that reasoning when they could be writing something more useful for a difficult case. The essence of these cases being they're not difficult in theory, and they're tiddly, all right? But the basic principles are not difficult. If, on the other hand, the court is not looking at it at all, then in a sense you have the Advocate General taking the decision, and the Advocate General is not judicial. Note, this is very different from what the court did in the case that I quoted to you with David Edward, Rodriguez Iglesias, and Joliet. There, the court absolutely was seized of the case and looked at the case and looked at the Advocate General's opinion, and then having thought about it and applied all the usual procedure, said, you know what, the Advocate General has done the necessary reasoning. So it's the trademark procedure is not on all fours with that earlier example, at least not according to me. And I think that perhaps you could use the early example. If you're going to be prepared to use the trademark procedure, well, why not use the earlier example as well? You could save the court an awful lot of time and effort, but this is a suggestion which has not so far found favour with the court. You know what? If you read the opinion and then you read the judgment, you may notice there's an awful lot of material which is exactly the same, the front end, right? Because the Advocate General has to set out the focus, what the court has to decide in this case, the legal background, the facts giving rise to the dispute, the questions referred if it's a reference for preliminary ruling. Lo and behold, when you get the judgment, you get the same material. And that is a great waste of drafting time, and it's a great waste of translation time. So, you know, if you really wanted to integrate what the Advocate General does and what the court does in a much more effective way, in cases where you have an Advocate General's opinion, the court could rely on what the Advocate General has already said, and which is already out there, as the front end, and then go on to its analysis. Well, if you're not going to use the Advocate General exclusively as extrajudicial manpower, maybe you should go back to the original idea and have the Advocate General doing real creative thinking, trying to assist the court where there is a real problem, and assisting the court by going the extra mile, doing the extra research, standing back and thinking, digging around to see if there are relevant cases which have not been cited by the parties. If you want the court Advocate General to do that, please give them the time and space to do that job. Don't say they have somehow to turn the handle and produce an opinion automatically like a chicken laying an egg every morning. and also don't require them, as the present system does, to down tools in the middle of writing an opinion for a grand chamber case in order to keep to the échéancier to produce their view in a trademark case. And that's something that I had to do on at least 2 occasions in order not to fall foul of the échéancier. I would put in 2 further points. I think you really should, if you're the court, explain to the reader, or at least in some way make it clear to the reader, how and where the Advocate General's work has influenced the court's reasoning. And you can do that by writing more clearly. And personally, I would not have a problem if the court were to explain courteously why it hasn't followed a particular suggestion. I wouldn't have a difficulty with that. But the court has a certain pudeur about not saying we didn't follow the Advocate General. And then final thought for you, maybe we should not use this word followed because it's such a strange word. I mean, in Ruiz Zambrano, the court and I ended up in the same place, but I have no idea whether they followed me. I mean, on a normal use of the verb, I would be, if the reasoning's totally different, I find it difficult to think that they followed me. Perhaps I influenced them. I don't think they followed me. If, on the other hand, you have a case where the court has taken on board the Advocate General's reasoning, which had 18 steps in it, and it's followed the reasoning right the way through, and then the final step, the Advocate General turned left and the court turned right, you're going to get a different answer. But in terms of the intellectual input, I think it's fair enough for the Advocate General to say, well, I did assist the court on that case, even though we disagreed on the conclusion. I'm going to stop there. I'm going to say, are there questions, further discussion?
Thank you very much indeed. Can we give a round of applause?